Hi everyone, hope you guys are studying well. The Institute of Chartered Accountants of India has issued the revision test paper which is applicable for the November 20 examination, and what I've done is I've put them here in the question answer form, and there's one detailed answer which has been given by the institute, and then there's a short answer. The short answer, this one, I've put it for each and every question so that when you're revising, you don't have to read the entire thing on the last day. You can just have a look at the short answer and just recollect what the question and how you're supposed to answer it. And the detailed answer is basically for you to understand how you are going to write the answer in the examination. You don't have to use the exact wordings which are used in the detailed answer, but that is the format in which you will write. You'll first explain the provision when it's a case study type of question. You'll first explain the provision, what the provision of the act says, and then you check according to the facts of the case, this is the facts of the case and hence this is the answer. So that is how you will ideally answer your case study type of questions. So there's a short answer and there's a detailed answer. I'll be attaching these notes in the comment section. So in case you want to download it and take a printout for your reference, you can do that. In the detailed answer, I have highlighted the important points, the points which you need to write in the examination, though not in the exact words, but those are the points which are important to that particular question, and hence it is important that you write down those answers in your exam paper. The questions asked here are important because they may be asked in your examination or they may not be asked, but it's best to go through them so that you get an idea of the type of questions that may be asked in the examination. So we'll quickly discuss all the questions and the answers to those questions so that there's a quick revision of the entire RTP, and it will help you revise on the last day. Going to the first question, I'll be reading the question slowly where it's important. I'll be highlighting the points which are important, so that when you are reading the question in the examination, you will read it in a similar fashion, just noting down what are the important points. So when I'm reading it, look at it carefully at what I'm highlighting, so that you know how to read the question and how to answer the case study type of questions. Okay, so going to the first question, X entered into a contract with Y to supply him 1000 water bottles at rupees 5 per water bottle to be delivered at a specific time. Thereafter, X contracts with Z for the purchase of 1000 bottles at rupees 4.5 per bottle, and at the same time told Z that he did so for the purpose of performing his contract entered into with Y. Z failed to perform his contract in due course, and the market price of each water bottle on that day was rupees 5.25 per bottle. Consequently, X could not procure any water bottle and Y rescinded the contract. Calculate the amount of damages which X could claim from Z in the circumstances. What would be your answer if Z had not informed about Y's contract? Explain with reference to the provision of the Indian Contract Act. So this is basically what your question is. He has sold the bottles at 5 rupees. He's entered into an agreement to procure it for 4.5 rupees. There's a breach of contract. Z has not provided the bottles, and on the day when the contract had to be delivered, the market price of the product was 5.25, which he could not procure. X, when entering into an agreement with Z, has informed Z that he is going to sell the product to Y at 5 rupees per bottle. So when there is a breach of contract, because he's informed Z that he's going to sell it at 5 rupees per bottle, the damages which he can recover is the actual damage which is incurred in the usual course of business. He cannot recover any remote losses, what we have studied under the Contract Act. So here he was supposed to get it at 4.5, and then when he sold it, he would get a profit of 0.5 per bottle. That is, in 2000 bottles, 500 rupees. Here in the first answer, the amount of damages which exclude claim is 0.5 into 1000, that is 500 rupees. 5 rupees being the selling price which he could not sell it at, and 4.5 rupees being the cost price, and 0.5 being the profit which he would have earned had Z provided the bottles to him. The second part of the question says, what would be your answer if Z had not informed about Y's contract? If Z had not been informed about Y's contract, then in that case he could have charged 5.25 minus 4.5 per bottle, that is 0.75 into 1000, that is 750 rupees. Because he is informed that I am selling it at 5, then he can recover only that much loss. Had he not informed, he could have recovered the market price and minus the cost of the bottle. Now, coming to the second question, Mr. Sham owned a motor car. He approached Mr. Vikas and offered to sell his motor car for rupees 3 lakhs. Mr. Sham told Mr. Vikas that the motor car is running at the rate of 30 kilometers per liter of petrol. Both the fuel meter and the speed meter of the car were working perfectly. Mr. Vikas agreed with the proposal of Mr. Sham and took delivery of the car by paying rupees 3 lakhs to Mr. Sham. After 10 days, Mr. Vikas came back with the car and stated that the claim made by Mr. Sham regarding fuel efficiency was not correct, and therefore there was a case of misrepresentation. Referring to the provisions of the Indian Contract Act, decide and write whether Mr. Vikas can resign the contract in the above ground. Now, first thing, what is misrepresentation? When you are making a statement of fact which you believe is true. Now, section 19 says when you can resign the contract, you can resign the contract, you can treat it as voidable if it is caused by coercion, fraud, misrepresentation, all of those things. So here in this case, he is saying that there is a misrepresentation. He has made a statement of fact which he believes to be true, but it is not true. Now in this case, the answer is that Mr. Vikas cannot resign the contract. Reason being that Mr. Vikas had an opportunity to inspect the goods by himself. When he said the fuel meter and the speed meter, all of those, he had the opportunity to inspect the goods, and hence if he had done the reasonable due diligence, then he would have not come back saying that the car is not working. So in this case, because he had an opportunity to do a reasonable due diligence, which he is not done, and taken the car based on the statement made by the owner of the car, Mr. Sham, because he is not done the due diligence, he can now not treat the contract as voidable. Third, define the term acceptance and discuss the legal provisions relating to communication of acceptance. Acceptance is the first thing that we study when we are doing the Indian Contract Act. When you are making a proposal and you receive an assent to that proposal, it will amount to acceptance. When is the communication of acceptance happening? Proposer, when he puts the acceptance in the format in which he cannot take it back from the if he's put it in post, then he cannot take it back, and hence it's said that the communication has happened. And to the person who is receiving it, once it comes to his knowledge, it will be said that the communication has ended. There was this example which we have in the module which says that communication when the letter has reached, and communication when the letter has been read. So when the letter is actually read by the person to whom it has been sent, it will be said that the communication has ended. So you can give those examples in the Contract Act so that it's more clear, and the answer is better because you've given your examples as well. Question number 4. To form a valid contract, consideration must be adequate. Again, consideration is what we have studied in the Indian Contract Act, which says that consideration is one of the most essential elements which is required if you want to enter into a valid contract. But the adequacy of consideration is not at all relevant. The courts have given previous rulings as well that the adequacy of consideration is something which the court should not be considered. It's a contract between the parties, and if both the parties agree to it, the court should not have a issue regarding the adequacy of consideration. Adequacy of consideration is a problem when the contract has not been entered into by free consent. So if there's coercion, fraud, misrepresentation, all of those things, then the consideration, whether it's adequate or not, will be considered, but otherwise adequacy of consideration is not relevant. Explain the term quasi-contract and state their characteristics. Again, one of the most famous, one of the most favorite questions asked by the institute. And quasi-contracts are basically, they don't have all the essential elements as laid down in the Contract Act, but they are contracts which have been entered into by law. There's an obligation to return money or return money to the person even though there is no formal agreement or a formal contract between the two. Finder of lost goods is one of the examples for that. Now coming to the Sale of Goods Act. J, the owner of a Fiat car, wants to sell his car. For this purpose, he handed over the car to P, a mercantile agent, for sale at a price not less than rupees 50,000. The agent sells the car for rupees 40,000 to A, who buys the car in good faith and without notice of any fraud. P misappropriated the money also. J sues A. A is a person who's got the car, the buyer of the car, to recover the car. Decide, given reasons, whether J would succeed. So the Sale of Goods Act says that if you have given your product to the mercantile agent and he's supposed to sell the goods, if he's selling the goods to the third party and if the third party is buying it in good faith, he does not know that there's a fraud involved, he does not know that the owner, the principal has asked to sell the goods at a particular price. So he's buying it in good faith, and now in this case A is not supposed to return the car to J because he's bought it in good faith, he's got it from the agent. The agent has acted without authority. So A is not supposed to give back the car to J. Then coming to question 7. Suraj sold his car to Sohan for rupees 75,000. After inspection and satisfaction, Sohan paid rupees 25,000 and took possession of the car and promised to pay the remaining amount within a month. Later on, Sohan refuses to give the remaining amount on the ground that the car was not in good condition. Advise Suraj as to what remedy is available to him against Sohan. Here the goods have already been given, the possession of the goods has already been given to the buyer of the car. So what remedy does Suraj have against Sohan is basically he can sue him for the recovery of the price of the car, the pending amount. He can also sue for recovery of the interest on the amount. So he was supposed to pay suppose by 15th of June and he is not yet paid. So from the date the amount is due till the date he actually makes the payment, he can sue him for the recovery of the interest of the car, interest on the amount pending on the car, and he can also sue him for recovering the cost of the proceedings which he would incur in order to recover the money which is not being paid to him. What are the consequences of destruction of goods under the Sale of Goods Act where the goods have been destroyed after the agreement to sell but before the sale is effected? So here if the goods, the agreement to sell has happened but the goods are actually not sold. So there are two things, one is uncertain goods and one is ascertain goods. If it is uncertain goods, then nothing can be done because the entire lot has been sold, is damaged, and agreement to sell has happened, so the seller will have to give the goods to the buyer. If it is ascertain goods and if the goods have been sold without knowledge, it has perished in the go down or something like that, then the contract can be treated as voidable and the contract can be treated as voidable by the party. So there are two things here. If it is sold without the knowledge and the goods have been destroyed, then there are no goods at all. The agreement to sell is there but the contract of sale has not happened, so it's now become void ab initio. And then the second thing is that if subsequently the goods without any fault of the parties have been become, then it can be treated as voidable. Distinguish between a condition and a warranty in the contract of sale. when shall a breach of condition be treated as a breach of warranty under the provisions of the Sale of Goods Act? So in Sale of Goods Act, you've seen what a condition is, what a warranty is. Condition is basically something that I want to buy this product for this particular reason. That's the main part of the contract, why you are in the first place entering into the contract. Warranty is something which is attached to the condition, the product that you are buying. So condition is the most essential thing. Example being, we had studied the example saying that I want to take this car to Himalayas. So I want to buy a car which will take me to the Himalayas. So if you give a Maruti Suzuki 800, you know that car is not going to go to the Himalayas. So that is a breach of condition. Breach of warranty is where the tires are not working, or the brakes are not working, the horn is not working. All of that is a breach of warranty. So what is the difference between the breach of condition and warranty? This is essential to the main purpose of the contract. This is collateral to the main purpose of the contract. Aggrieved party, if the condition has been breached, you've given me a car which you know that I'm relying on you, and you know that this car is not going to take me all the way to Himalayas, then I can claim damages and I can repudiate the contract. I can do both. But when there is breach of warranty, I can only claim damages. A breach of condition may be treated as breach of warranty. I may treat it as a breach of warranty, but a breach of warranty cannot be treated as a breach of condition. Second part of the question said that when shall a breach of condition be treated as warranty? When the sale is subject to conditions to be fulfilled by the seller and the conditions are yet to be fulfilled. The buyer may decide that it does not want to, it may waive those conditions. The buyer elects to treat the breach of condition as breach of warranty. Acha, theek hai, you've given me the car now, I'll treat it as breach of warranty. I'll just give me the damages and I'll keep the car even though it's not taking me to Himalayas. Contract of sale is non-severable and the buyer has accepted the whole goods or any part, and the condition of warranty is excused by law. In those cases, you can treat the breach of condition as breach of warranty. Now, coming to the Indian Partnership Act, explain the provisions of Indian Partnership Act relating to the creation of partner by holding out. Partner by holding out is basically a person who is not the partner of the firm, but he shows himself as a partner of the firm. Partner by estoppel is the other name which is being given to it. So he himself or some third party shows that he is a partner of the firm, and he acts as if he is a partner of the firm. In that case, if someone gives credit to the firm based on the partner by holding out, then the partner by holding out will be responsible for the credit that has been received by the firm by showing that he is a partner by estoppel. There's a case study in question number 11. Master X, so it's a minor, was introduced to the benefits of partnership Messrs ABC and Company with the consent of all the partners. After attaining majority, more than 6 months elapsed and he failed to give a public notice as to whether he elected to become or not to become a partner in the firm. Later on, Mr. L, a supplier of material to Messrs ABC and Company, filed a suit against Messrs ABC and Company for recovery of the debt due. In light of the Indian Partnership Act, explain to what extent X will be liable if he failed to give public notice after attaining majority. Can Mr. L recover his debt from X? What does the Indian Partnership Act say? Indian Partnership Act says that if you are a minor, you have been admitted to partnership with consent of all partners, great, you can be admitted as a partner. Now, once you attain majority, within 6 months of attaining of majority, you will have to give a public notice saying whether you want to be a partner or you don't want to be a partner. If you don't give that public notice, you become a partner from the date that 6 months expires, and your share in the firm, your profit sharing ratio, shares in the assets will be the same as it were when you were a minor, and you will be personally liable for all the acts of the firm. In this case, because he is not given the notice and 6 months have already expired, he will be personally liable for all the actions done by the firm, and Mr. L can also recover the debt from X like he would have done from any other partner. Now coming to Limited Liability Partnership Act. What do you mean by a designated partner? Whether it is mandatory to appoint a designated partner? A designated partner is like the CEO of the company who does the management of day-to-day affairs of the company. So yes, it is mandatory to have a designated partner. You need to have at least 2 individuals who are designated partners, out of which one person has to be a resident in India. Resident in India meaning a person who stays in India for a period of 182 days or more. So yes, you need to have a partner. If you have body corporates as your partner, which you can have, in that case you will have to appoint 2 individuals who will be acting as designated partners, because body corporate cannot do everything. It can't do the day-to-day management of the company, LLP, sorry. Now coming to Companies Act. Mr. Anil formed a OPC on 16th of April 2018 for the manufacturing of electric cars. The turnover of OPC for the financial year ended 31st March 2019 was about rupees 2.25 crores. His friend Sunil wanted to invest in his OPC, so they decided to convert it voluntarily into a private limited company. Can Anil do so? What does the provision of Companies Act say regarding OPC? If you are a OPC, if you want to get converted into a private company or a public company, you can do so, provided 2 years from the date of incorporation has expired. In this case, he is incorporated on 16th April 18 and on by 31st of March. So before 2 years of expiry of from the date of incorporation, he's decided that he wants to convert it. So there are 2 exceptions where you can convert your OPC into a private limited or a public limited company. One being that your paid up capital is more than 50 lakhs in those 2 years, or your turnover goes about 2 crores. If any one of these conditions has been satisfied, you can convert your OPC into a private limited company, even though the 2 years from date of incorporation has not expired. So in this case, because his turnover is 2.25 crores in the first year itself, he can convert it into a private limited company. Coming to the last question, explain clearly the doctrine of indoor management as applicable in case of companies registered under the Companies Act 2013. Again, one of the most favorite questions asked by the institute. Explain the circumstances in which an outsider dealing with the company cannot claim relief on the grounds of indoor management. Indoor management is basically an exception to the doctrine of constructive notice. Doctrine of indoor management, what does it say? That if I am dealing with the company, then I am supposed to look at the charter documents, which is constructive notice, but I am not supposed to look at whether the company has done the day-to-day internal affairs of the company. So they've called a meeting, okay. Whether they have given 21 days notice, I am not supposed to have a look at that. Whether there was adequate quorum present, I am not supposed to look at that. Whether if the meeting was adjourned, whether it was again called at the after a week at the same place, same time, I am not supposed to look at that, because all of these things are the internal management of the company. When I am dealing with the company, I have to assume that the company has complied with all the internal regulations which it has to comply as per its articles of association. So that is your doctrine of indoor management. What is the exception to the doctrine of indoor management? When can I not take the benefit of the doctrine of indoor management? When I know that the company has didn't have quorum and has approved the transaction with me, or when there's a case of forgery. In all of these cases, there are 3 most important pies: when I have actual or constructive knowledge, when I have a suspicion that partner was not there, so how was the quorum, the director was not there, so how did they have the quorum. So if I have a suspicion that they've not complied with it, and the third case is forgery. So in these 3 cases, the doctrine of indoor management, the benefit cannot be taken. In all other cases, the doctrine of indoor management benefit can be taken. I hope you've understood it well. Please go through the video and the question and answers before you go for your examination. And I hope you like the video. If you have any queries, you can drop it on my phone number, or you can drop it in the comments below, and I'll get back to you. Thank you so much.